Dear students, and so this is the last class with regard to the dispute settlement and within this particular module. And this class we are going to discuss about the appellate body mechanism within the dispute settlement understanding. So, the appellate body considers cases from the panel. So, the appeals will be came to the appellate body. So, the panel is the preliminary body and any one of the member countries, those who are party to the dispute, can appeal to the appellate body. And today we are going to discuss about the appellate body and also what happened to the appellate body in the recent times and what is the contribution of the appellate body in law making international trade law. And we will see that the constitution of appellate body and the entire process of appellate body in this particular class. So, here there is a lot of difference between panel and appellate body, and appellate body is a permanent body of 7 members. 7 appellate body members are appointed by the DSB, and these 7 members sit in panels and they come out with appellate body reports. So, this is the final stage of adjudication within the dispute settlement system. So, here the members, so as I told you from the very inception of the WTO, appellate body has made a fantastic, they have come out with a lot of reports and they have contributed to the entire development of trade law jurisprudence through the cases which they dealt with. And the appellate body only concerned about the question of law in the disputes raised by the parties. The appellate body reviews the challenged legal issue and factual issue appellate body is not going to look into. The appellate body may uphold, reverse or modify the panel findings. So, it have like the Supreme Courts of the national systems. They can uphold, reverse or modify the panel findings. So, you can see that the panel reports almost it is you can see that a number of appeals. So, if you see the percentage of appeals from the panel reports, around 68% of the panel reports are appealed, and the arbitration proceedings, 67% of arbitration proceedings, 67% of the reports are went to the arbitrators finally. It means that there is a higher number of dispute between the members and they are not able to agree with the panel, with the appellate body. Finally, for each and every issue they went for arbitrations, non-compliance proceedings, review proceedings. So, more than 50% of the panel reports are appealed. It shows that the intensity of disputes between members. So, whether actually the members use the appeal provisions or misuse the appeal provisions, we do not know, but 68% of the panel reports are appealed. Almost similar percentage of disputes went for arbitration. Unfortunately, all the 7 members of the appellate body, their term of appointment is expired with November. So, we are in November for the last 3 years. There is no members in the appellate body. So, how it is happened and why it is happened we will discuss later. So, appellate body, a sizable number of cases came to the appellate body for review. So, what is the jurisdiction of appellate body? So, either members of a complainant and respondent in the panel report can appeal, and sometimes both sides appeal. Yet there was no such systems, and appeal will be based on points of law and legal interpretation, no factual interpretation. And each appeal is dealt by 3 members of this permanent body, a 7-member body. And it is definitely it is a very small body, dealt with the largest number of cases and appointed for a period of 4 years, and some of the members are reappointed for another once. So, that means total 8 years. One time appointment is for 4 years, and they can continue up to 8 years if there is a reappointment. So, 8 years, up to 8 years they can be there in the appellate body, and there is a lot of changes. Appellate body is an innovation from the GATT procedures, and they have to be individuals, say that is of recognized standing in the field of trade law, international trade, not affiliated with any government. They may be university professors, practicing lawyers, past government officials, senior judges, etc. And each panel, a chairman is elected among the members to serve as 1-year term. That means, appellate body, there will be a chairman, will be elected for 1 year, and every 1 year they will change, and chairman is responsible for the overall working of the appellate body system. So, each case is heard by 3 members, and each 3 members elect 1 presiding member. So, and they dealt with these cases. So, appellate body, what is the appeal, the appeal provisions, and what is the role of appellate body, which is mentioned under the easy hormone case. The appellate body said the appellate review is limited to appeals on questions of law covered in a panel report and legal interpretations developed by the panel. Findings of fact as distinguished from legal interpretations or legal conclusions by a panel are in principle not subject to review by the appellate body. So, simply they said that is clearly the appellate body will consider only the law, interpretation of law, not facts. And also it clearly said the appreciation of evidence. That means, so if the panel made a mistake in an objective assessment of the facts, so it is the duty of every panel to make an objective assessment of the facts in every case. Then is there any mistake or there is any error in appreciating the evidence, then the appellate body can consider that cases as well. So, the appellate body's role is very limited to the interpretation of law and not facts. So, the appellate body have the power to uphold, modify or reverse the panel findings, and total time frame which is given is 60 days time, with maximum time frame is 90 days. But in practical we saw that in many cases the appellate body has exceeded this 90 days time because of various reasons. So, the DSB has to accept the reports or reject the reports within 30 days time, and this rejection again the negative consensus principle is applicable to the appellate body cases as well, which is not happened so far. And the clear time frame is given for the appellate body principles, that is the notice of appeal is given and appellant submission within 10 days and total 15 days time for submissions, third party submissions within 25 days, and then oral hearing and other hearings will be done within 30 days period of time, and the appellate body report will be made within 60 to 90 days time, and DSP meeting adopted within 120 days time. So, the maximum time frame is given this, maximum time frame 120 days. So, once the report is out, what is the next step? As I said, like panel, the appellate body also asks the members to bring its policy into in line with the rulings and recommendations. So, that means if the appellate body found that one of the member has violated any one of the provisions of an agreement, they will ask that measure to be in conformity with the provisions, and the reasonable period of time mentioned is 15 months time. If it is impracticable or there is any dispute with regard to this 15 months time, so the members can go for arbitration and decide the time. So, and the dispute settlement is procedure is very clear. So, I said that if they cannot agree on the implementation period, they can go on with arbitration procedures. So, any group, any people can call to adjudicate certain questions at several stages of dispute settlement process. Arbitration is, it is definitely an alternate method of dispute resolution mechanism, even though the article 25 says that you please find out the possibility of outside the WTO for arbitration, but arbitration is final and arbitration results are not appealable and but can be enforced through DSU. So, arbitration is final and no appeals from such arbitrations. So, arbitrations which you can see, as we already said that even appellate body members been called upon to determine through binding arbitrations under 21(3)(c). So, if there is any dispute with regard to the implementation of reasonable period of time, so there can be an arbitration under article 21(3)(c). So, appellate body here they sit, appellate body members sit not as appellate body members, they sit on in their individual capacity as arbitrators, and they come out with arbitration reports. So, dual role is given to arbitrations. I think it is a high time for to change this particular position of arbitration should be given to other forums like the Permanent Court of Arbitration, so that the appellate body can discharge its functions quickly. So, here again suspension of concessions. So, if one member says that satisfactory implementation is not done, then there can be an arbitration. So, if satisfactorily not done the implementation, there can be an arbitration. And again, as I told you, such arbitrations can be done. This arbitration can be done by the panel members, and or arbitration is alternatively available under article 25, and this arbitration is not appealable. So, arbitration and under 21(3)(c) is not arbitrable, and if any arbitration with regard to party subject to retaliation also can ask for arbitration. So, if there is any dispute with regard to the nature of suspension of obligations or the extent of or the quantum of compensation, the quantity of compensation, they can go for 20-6 arbitrations, and finally, the arbitrators decide the compensation to be paid or the retaliation, the suspension of concessions to be made or retaliation, whether they can make the retaliations. So, what is the reasonable period of time? Reasonable period of time which is mentioned is 15 months time. So, what is this reasonable period? So, it is the period which is proposed by the members. So, and period of time mutually agreed by the parties to the dispute within 45 days. If there is any dispute between this implementation period, they can go for arbitrations, and the arbitrations, the gate, in such arbitrations the guidelines should be followed a reasonable period of time, and this arbitration is finally applicable on the members and which is not appealable. And what are the arbitrator's power in this particular case under 21(3)(c)? It says that their responsibility includes examining closely the relevance and duration of each of the necessary steps leading to the implementation to determine when a reasonable period of time exists. Reasonable period of time. In non-violation complaints, so that means under article 21(3)(c) arbitrations, upon request of either party, include a determination of a level of benefit which have been nullified or impaired, and may also suggest ways and means of reaching mutually satisfactory adjustment. So, if there is any dispute with regard to the implementation, compensation, sanctions, you can go with arbitration. And another important provision is acceptance of the expert opinions. For example, in some of the agreements which provides for acceptance of expert opinions, and for example, article 11(2) of the agreement on sanitary and phytosanitary measures, SPS agreement, article 14(2), 14(3) and annex 2 of TBT agreement, article 19(3), 19(4) and annex 2 of article 7 of the GATT 1994, and article 4(5), 24(3) of the agreement on subsidies and countervailing measures. So, all these agreement provides acceptance of expert opinion in expert opinion by the appellate body. And the most important provision is the suspension of concessions. If a member is not listening to or not in conformity with the provisions of the report which is produced by the appellate body or the panels, then if any member fails to bring its conformity with the measures, the DSB authorize suspension of concessions. Suspension of concessions within a reasonable period of time. And what is this 22(3) suspension? Suspension of concessions, goods to goods. That means, if the question is with regard to goods, then the suspension will be allowed on goods sector. With respect to the current service sector, that particular service sector, and if it is related to intellectual property rights, and then the export or import the intellectual property right concerned. So, that means the suspension of concession will be in respective sectors between the trade between two countries. And we said the DSB also do the surveillance of the implementation mechanism. So, if the members fail to implement, or there is a disagreement among the implementation period, the members to enter into negotiations between the complaining party. If there is no compensation, no compensation is agreed, then again sanctions, limited sanctions will be imposed, which is known as the suspension of concessions and obligations. And then if a particular sector, there is no trade between two countries on that particular sector, then the dispute settlement body grants authorization within 30 days and a retaliation authorization. That means sanctions should be imposed on the same sector. If it is not practical, the sanctions can be imposed on a different sector of the same agreement. This is retaliation authorization. So, first sanctions, to retaliation authorization also can be done, and we can see retaliation authorization is given to many countries, So, Canada got a retaliation authorization in Byrd Amendment in 2004 against the US. Brazil, Chile, India, Japan and other countries got an authorization. And in 2005, Canada imposed 15% surtax on US on goods, swine, cigarettes, oyster and fish. India got a chance to impose these retaliatory sanctions against the US, but it never did. Only Canada imposed 15% additional taxes on US goods, specific goods. And next is, so we talked about retaliation, now is cross retaliation. If, as we said that practically possible, it should be on the same sector. If it is practically not possible, it should be on the different sector of within the same agreement. And now, if the same agreement, there is no trade between two countries, not possible, then another sector, allowing the same level of concessions to be suspended on another agreement. For example, a small country like Antigua and Barbuda got an authorization from the WTO to retaliate against the US on recreational services. Recreational services, they got a retaliation, but there is US, there is no recreational services, the services between the two countries. So, a cross retaliation is sanctioned to the tune of 21 million against the US patent intellectual property sector. Even though they got a retaliation again in the service sector, but a cross retaliation was on the intellectual property sector, patent, copyright, trademarks and other IP as well as service sectors. So, if a country does not have a particular trade, goods trade with other country, you can retaliate against, cross retaliation against in the intellectual property sector. So, absolutely the cross retaliation, even a small country like Antigua and Barbuda was able to put sanctions on the United States even for a very small amount of 21 million. Before the WTO, small countries or least developed countries or even developing countries find it very difficult to put sanctions, and the countries like India think twice to put sanctions on the US. But here under the WTO system, a small country like Antigua and Barbuda retaliated against the United States, and that is the strength of the WTO dispute settlement system. The appellate procedures which we already discussed about this particular table. So, developing countries, always we say that there is special concessions for developing countries. So, Indonesia auto case also, Indonesia asked for the special concessions on special concessions as a the particular circumstances of the country. So, what the appellate body said? So, the Indonesia said that our economy is to near collapse. So, the particular circumstances you have to take into consideration affecting the matters of Indonesia as a developing country. So, what they said? So, I quote, I therefore conclude that an additional period of 6 months over and above the 6 months period required for the completion of Indonesia's domestic rulemaking process constitute a reasonable period of time for implementation of the recommendations and rulings of the DSP in this case. So, the developing countries special concessions are available, but mostly it is not given by other countries. So, here as I told you, an appellate body was established in 1995, and the members, there are so many members where 7 people each appointed from time to time, and they have contributed up to 2020 very well. And this was the photograph of the last appellate body. So, you can see the various personalities from different countries. So, the last person who was retired in November 2020, not I would say that they retired and then nobody was appointed after 2020. So, presently the appellate body is without members. Why it is happened? How it is happened? It is happened mainly because the appellate body members are appointed to the appellate body through consensus. So, sometimes this consensus make problems as well. There is no voting system in the WTO to implement its decisions, it is consensus. So, the US non-cooperates, the non-cooperation of US has prevented the members from appointing appellate body members. So, from 2020 for the last 3 years there is no appellate body members and all the appeals filed. So, it is very interesting to note that the US is not allowing to appoint members. So, the main argument of US is that most of the appellate body reports are against the US. So, this is I would say that this is a colonial approach, the earlier colonial approach of the mindset of the countries to approach these international adjudicatory bodies, because they think that yes, I am contributing to the funds of WTO. So, they should give the judgment in favor of me. This is the attitude of the countries like US. And but at the same time you can see that after the no members after 2020, the US has filed appeals to the appellate body. So, it is something like that, I file appeal to the appellate body where there is no members, where I only prevent other members from appointing appellate body members. So, I think the multilateral trading system has to find out other means and methods of appointing members. So, the system has worked very well from 1995 onwards. That means exactly 25 years, a quarter of a century, the multilateral trading system, the appellate body has one of the cornerstone contributed to the development of international trade law and come out with reports with clear interpretation of the WTO law. And this made some of the countries worried about the ultimate, because there is no appeal from the appellate body. There is no other court to go, no other place to go rather than to comply with the provisions. And also the countries, big countries like the US worried about the small countries going on with retaliation like what is happened to in the case of Antigua and Barbuda. So, they think that this particular system is against them. So, they try to destabilize the particular system, but actually this process make the entire world trading destabilize. Now, almost 3 years the members were not able to find out an alternate system of dispute settlement in the appellate body. They are not finding it. So, it is an impediment to international trade, and so I believe that it is the duty of all 164 member countries to come out with an alternate solution. If the US is not agreeing, let them not agree, because they are not agree to many of the agreements, important agreements, like for example, in the case of UNCLOS 1982, US is not a party. So, other 163 member countries can come out with an agreement. Again the question is, because the history says it is the US that proposed the ITO, International Trade Organization, and finally the US said that we are not going to sign, we are not going to ratify. They signed it, they never approved it. So, that was the end of ITO, because US is an economic power and which is a largest contributor to the world economy. So, without US is also a problem. So, it is a concern. So, it is a concern of every countries, especially I would say that the concerns of developing and least developed countries, that there is no appellate body. So, lack of appellate body is a huge vacuum which made in the international trade. So, the members should come out with a solution to these alternate measures, for example, recourse to Article 25, alternate mechanism for arbitration. They can approach other forums for arbitration, and the methods like arbitration or alternate dispute resolution mechanism can be used for resolving disputes in case of appellate body. So, in conclusion, I would say that the panel, appellate body and the entire dispute settlement system of the WTO has contributed immensely to the international trading system for the last maybe the 25, 26 years or 27 years, and the destabilizing of appellate body is a mistake. So, it is a failure to the international trading system. So, it has to be restored at the earliest. Thank you.